2018 meeting of the Tennessee Alarm Systems Contractors Board. Ms. Vest, will you please call the roll?
Scott Cockcroft.
Here.
Keith Harvey. Vivian Hickson.
Here.
Karen Jones.
Here.
Mackenzie Roberts.
Here.
Let the record show that Keith Harvey is not present, but you do have a quorum, Madam Chair.
Okay, thank you. The next item on the agenda is a motion to adopt the agenda as presented for today's meeting.
Madam Chairman, I make a motion we adopt the agenda as it has been presented. Second.
Okay, we have a motion by Mr. Roberts, a second by Mr. Cockcroft to adopt today's agenda as presented. All in favor, voice by saying aye.
Aye.
All opposed? The agenda is adopted. The next item are the minutes from the October 19th, 2017, December 7th, 2017, and January 17th, 2018 board meetings. Have the members had an opportunity to review these, and if so, a motion to approve?
Madam Chairman, I make a motion that we approve the minutes as they have been recorded and presented to us.
Second.
Okay, we have a motion by Mr. Roberts, a second by Ms. Jones to approve the minutes as presented. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. The next item is the election of officers for the board. Ms. Best.
Yes, but I'd like to, if I can, make a statement about the minutes. You have 3 sets there. There were some corrections that needed to be made to the minutes, and it took us that long to get.
Okay, thank you.
For the election of officers, Mr. Harvey is not here, so we can postpone the election, or we can go ahead and vote, if you wish, to have the members stay the same. That is Vivian Hickson as chair, Roberts as vice chair, Karen Jones as secretary. I can ask for a motion to keep the board the same.
I would make a motion that we maintain our current officers. Second.
Okay, we have a motion by Mr. Roberts and a second by Mr. Cockcroft to maintain the current set of officers. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Thank you. Congratulations.
Thank you.
You have now we're going to vote for Robert's Rules of Order.
Have there been any changes to the Roberts Rules of Order?
The last changes were a couple of years ago, which as a small group would apply to us pretty well here. It does allow for discussion prior to making a vote or making a motion. It does allow the presiding officer to comment, and also allows the presiding officer to vote on issues. So I would make a motion that we adopt the latest edition of Robert's Rules of Order for our guidelines. Second.
Okay, we have a motion by Mr. Roberts and a second by Mr. Cockcroft to adopt the latest version of the Roberts Rules of Order as it pertains to this board. All in favor, voice by saying aye.
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 All opposed? The motion carries. Now, Ms. Thomas, your legal report is next. Is that the order that we're going to go in? Okay.
Okay, I have a few cases as well as Mr. Huffman, so I'll just go ahead and get started with the legal report.
Did we introduce him?
Don't recall. I'm not sure if Stuart Huffman's been formally introduced to the board. He will be disciplinary counsel for your board. I will continue to serve as program attorney, handling rulemaking and day-to-day legal advice. Case number 1 is 2017-055-121. This complaint opened alleging that respondent is engaged in unlicensed activity in violation of Tennessee Code annotated 62-32-304. Complainant stated that respondent promoted camera installation in residences without a CCTV license. No response was given, and an investigation was requested. During the investigation, respondent stated that he has been in business since January 2009, and his primary business is installing and/or repairing surround sound and computer systems for homeowners. Respondent stated that he has only completed one job that involved IP cameras using Cat5 cables. Respondent stated that the equipment was provided to the customer. Respondent stated that he was unaware that he would require licensure, but would be interested in researching the cost versus benefit of becoming a certified alarm systems contractor. Aside from the complainant's allegation, there was no evidence found of respondent engaging in unlicensed activity. My recommendation is to close.
Madam Chairman, if I understand correctly, the respondent here has indicated that he was installing a closed-circuit television system using IP cameras and Cat5 cables, which would fall under our jurisdiction and the statute we operate under. Given the circumstances here as they have been continued on, I would make a recommendation that rather than close this, we send this respondent a letter of warning. I think in doing that, that would make perfectly clear his responsibility and the fact that licensing would be required for the activity that he has admitted.
I second.
Okay, we have a motion by Mr. Roberts, a second by Ms. Jones to send this respondent a letter of warning concerning unlicensed activity. All in favor voice by saying aye. Aye. All opposed? The motion carries.
Case number 2 is 2017-062-721. This complaint opened alleging dishonest dealing by respondent in violation of Tennessee Code Annotated 6232-319D. Complainant states that prior to his deployment, he entered into a 5-year contract with the respondent company upon the advice of the salesman. Complainant states that he was informed that respondent company would release the complainant from his contract in the event he and his family were relocated by the Army. Respondent offered no response to the instant complaint, and an investigation was conducted. Respondent informed the investigator that they did not receive a copy of the complaint for response, and after reviewing the complaint, the legal counsel for the company did not find any wrongdoing. Respondent states that complainant was not misled regarding the contract. Respondent also claims that complainant was rude with the employees, and an exception has been made to cancel the contract based on a breakdown in client-company communication. My recommendation is to close, as there is no evidence to substantiate either party's claims.
I have a question. Why did they not respond to the complaint?
Their indication to the investigator was that they did not receive the complaint in order to respond.
Is it sent to the correct address? I mean, have they moved where they couldn't have gotten it, or was it sent by registered mail?
To my knowledge, it was sent to the address we have, but we don't have verification that it was actually received. It's usually sent sometimes via email, sometimes regular mail. That's handled by a different department now, so I can look back and try to verify, but I'm not really sure. So I found it hard to hold that against them if I couldn't verify that they received it.
So they didn't let the guy out of his contract?
They did cancel the contract.
Notification, whatever the process may be, going to be a problem in the future. We got this company saying they never received the complaint against them. Is this going to be an ongoing issue?
I have not seen this in my research to be a continuing problem. Like I said, I'm not sure of the address. I can ask Carol to look at the file to see if we have certified mail receipt, but I don't know as a general rule whether or not the complaint is sent certified mail.
Has the process changed here recently in some fashion?
I don't believe our process has changed, but the department that handles it has changed. They're now centralized to handle all of our programs.
How did they end up responding if they didn't?
They sent an investigator.
I sent this case for investigation,
Okay.
and they spoke to an investigator.
We have penalties in place under our rules for for companies that do not respond. And if we don't have some assurance that they're getting the complaint, then it's kind of hard for us to be critical of them for non-response.
What I can do is, we can defer this, I guess, to the end of the legal report. I can ask Carol to pull that case up and see if we have a certified mail slip for this
Actually,
case.
I have it pulled up.
Okay.
It was sent certified mail, but was not returned. So we sent it to the file. Yeah, the green card was not returned. It was not signed for. But it was sent to the address that we have on file.
Well, I don't have a problem with what your recommendation. I think it's a solid one. However, I was just looking beyond that to see if it was a problem that we'd be encountering more frequently down the road. So.
And I can only offer
Okay.
to that I have not seen this be an increased problem in our programs.
Maybe something we need to just keep an eye on. Madam Chairman, I make a motion we concur with the recommendation of our council and close this particular issue.
Second.
Okay, we have a motion by Mr. Robertson, excuse me, a second by Mr. Cockcroft to concur with our council's recommendation to close. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Case number 3 is 2017-071-511. This complaint opened alleging unprofessional conduct by respondent company in violation of Tennessee Code annotated 6232-319D. Complainant states that he attempted to contact respondent and was connected to a monitoring company. Complainant states that the monitoring company denies offering services for respondent since 2016. Respondent indicates that complainant does not have an account with them. Respondent states that the complainant's account was owned by a similarly named incorporated company, which was subsequently sold in 2015. Respondent states that his company, formed as an LLC, opened after complainant's contracting with the unrelated company. Respondent states that they are not responsible for serving as the alarm contractor for complainant. Research corroborates respondent's explanation of the complainant's confusion. My recommendation is to close.
They're just similarly named companies, and it is unrelated. It's completely
They are
unrelated.
unrelated. They're very similarly named, but they are two separate owners or two different companies.
I'm not sure I understand the nature of the complaint. Alleging unprofessional conduct, but what was the problem here?
So the complainant alleged that he tried to contact this company and was forwarded to a monitoring company who says that they hadn't serviced his account since 2016. He's saying that he was never informed that this information had changed, that he didn't have this particular monitoring company anymore.
And he called the wrong company altogether, and he asked, "Do you monitor my system?" And they said no, basically. So he thought his system was not being monitored. So he complained against this wrong company that he called.
Correct.
Is that?
Yeah, but there's a line in there that says complainant states that the monitoring company denies offering services for respondent since 2016.
Right, and so that may be an issue against the particular monitoring company, but the company he filed the complaint against, they had no dealings with this complainant. That's a separate company.
I don't know this, but I'm just guessing. It sounds like it could possibly be that whatever monitoring center he got maybe was the right monitoring center, and maybe they did monitor him back in 2016, but it was for this other company that we can't hold the company that the complaint was against responsible, because, I mean, they really had it wasn't their problem, their fault at all. It was just he called the wrong number. He called a company that had nothing whatsoever he'd never had any contracting, any relationship whatsoever with them.
I wouldn't interpret it that way. I would interpret this that probably the original company that the complainant dealt with was sold to a subsequent company, or perhaps the company reorganized as an LLC, which technically would make them a subsequent company. And because of the comment that let me see if I can find it here in the complaint, that his system wasn't monitored since 2016. It's just confusing.
Right, and like I
Yeah,
said,
it really
that's
is.
what the monitoring company told him, which is separate from the responding company. So my recommendation was to close against this responding company. If the board sees fit to investigate that monitoring company, I think that's a separate issue.
I personally don't think so. I think your recommendation is solid, but it's just the circumstances that were confusing and was looking for a little clarification. Madam Chairman, I'd make a recommendation that we concur with our counsel and close this, even though it does seem to be a bit confusing.
I have a motion by Mr. Roberts to concur with our council's recommendation. Do we have a second?
Second.
And a second by Ms. Jones. All in favor, voice by saying aye.
Aye.
All opposed? Okay, now that we voted on that, I'm confused, and I don't know, and I think the rest of us are too. Did this complainant think that this monitoring company was still monitoring their account, but was failed to be told that they
Right,
weren't?
and that's part of his basis for alleging unprofessional conduct. He's saying that he thought he had this particular company monitoring his account that was never monitoring, or they hadn't been monitoring since 2016.
So was he paying for monitoring service that he wasn't getting?
His indication was that, yes, the money was still being deducted from his account.
Then I think we need to open a complaint against the monitoring company to see where this goes. Does that satisfy?
Or more specifically, against whoever is actually drawing money out of his account, whoever he's paying, if that is a
Yeah.
monitoring company or if that is a company with a similar name.
And you're saying there's absolutely no connection between the company he called and the company he used to have business with? They're two.
Right, other than they're similarly named, they have two different owners.
No current employees, officers,
Not that
nothing
I know
like
of, but I'd have to do research to confirm that.
Because when he calls a number and it ironically comes up to a similar company or whatever, it just sends red flags up. But you know what we need.
Absolutely.
Yeah, I think there's more to this
Okay.
than we've seen thus far.
Okay, number 4.
Number 4 is being removed from the legal report. Number 5, 2017-072-661. It's an anonymous complaint alleging employer respondent being unregistered. Employee is a salesperson and does not have access to records, diagrams, plans, or other sensitive information pertaining to monitored, installed, or proposed alarm systems. Therefore, the employee is not required to be registered. However, the respondent has applied for a registration of this employee so as to make sure that there are no issues in the future. Recommendation is to close.
I would question whether or not a salesperson, the fact that they didn't have access to records, diagrams, plans, or other sensitive information.
Normally, a salesperson would require registration. Now, I guess there could be some peculiar circumstances where that wasn't the case.
But in this case, the salesperson is actually doing home automation and not actually alarm systems. Further respondent.
The anonymous complaint didn't specify what activity the person was doing.
Like the previous case, it sounds like there's more to this than has been revealed at this point. We get a complaint that there's someone out installing alarm systems The response is that the employee is just a salesperson. Salespersons have to be registered unless there's some very unusual circumstances there. Because they're involved in, if they're dealing with alarm systems, then they're selling alarm systems, and that falls under the statute quite clearly.
What all kind of home automation does this company do?
It wasn't specified. I believe, based on the respondent, they do sell alarm systems. However, these individuals do not
Probably
sell.
CCTV also?
Probably CCTV. Home automation, cameras.
Even cameras would require that the person be licensed if he was selling cameras.
I'm
mean,
like
if we
Ken.
take-
I thought all salespeople were supposed to be registered,
They are. It's
no matter what.
Well, if someone it sounds like they're trying to say that he wasn't selling security systems. If he wasn't selling a security system and he wasn't selling a camera system, he doesn't have to be licensed. If we took it at face value that he's only selling home automation, he wouldn't have to be licensed, in my opinion. I just doubt seriously if an alarm company has an employee that only sells home automation.
What kind of home automation could you offer if you didn't offer cameras and security? Just flip your lights off and on?
Well, you could thermostats and lights, and I agree with you. I doubt that that's all the person is selling, but that's, unless we're questioning their response, and if we're taking it at face value, then they don't have to be licensed.
So
I
this
seriously
is a
doubt that-
licensed company. It's just this particular individual that wasn't registered. Is that correct?
Maybe I can help just a little bit. The individual did make application on November 16th of 17. The individual you're talking about with this complaint made application, but his application was denied for material misstatement. So we have notified the company that he would need to reapply and provide us with proper information. So they have attempted to register the employee.
When did this complaint come in? Approximately.
Around November 20th, 2017.
When did the employee make application?
November the 16th.
Do we see a correlation here?
I would say we do.
They got caught, so they send in the registration.
But they knew he couldn't pass. That's why they didn't register him to begin with.
No, we don't know that because he could have just left a blanker on his form or something. So, yeah, we would not logically necessarily assume that.
Well, there's actually no evidence that this person actually sold anything either.
It was
Also, an unsuccessful salesman doesn't have to be licensed.
And they want to keep him and they want to get him registered.
I-
Although he's making more money for him.
Do they have other employees in this organization that might be in sales that are also not registered?
Actually, the next complaint,
Is the same?
but that person's registered.
Oh,
Here's my recommendation on this current one we're talking about. If they could provide documentation during that time period of several sales of just home automation, that would prove that, I mean, they're probably not going to supply us proof that he sold alarms, and I don't think that they're necessarily going to be able to provide proof that he sold just home automation. But if it'd make me feel better if I could see at least two actual sales, or not me, but you see paperwork signed by a customer that at least two things were sold, that's all it was home automation during that time period.
Baloney.
Yeah, security.
That ain't gonna happen.
I don't think that would, but otherwise, I think it's, the person is selling security systems
Yeah,
and they got caught.
and got caught, and so now he's making application. That would certainly appear on the limited amount of information we have was the case. However, it does look like that they've made application, and in the past, the board has basically tried to bring people into compliance more than anything else. And I would, Madam Chairman, I would make a motion that we send this respondent a letter of warning. Maybe we should say a stern letter of warning that that they should not be engaged in
The industry.
items that fall under our statute. So, stern letter of warning.
So is he going to resubmit his application for registered employee that we know about? Is this
Registered employee. Or
person
unregistered.
going to submit his or her application for registered employee again since there was,
I don't have a record of that because we have just denied it.
oh, okay.
And we've sent the correspondence to,
They haven't had
just
time to
recently,
respond.
they
yet.
have not, right.
Okay. Okay, we have a motion by Mr. Roberts to send a letter of warning with stern language to the respondent regarding their employees if involved in activity that would require them to be registered, to have all registered. Do we have a second?
Second.
And a second by Mr. Cockcroft. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. Number
Number 6, 2017-073-921. This is related to the last complaint. Anonymous complaint alleging employee respondent being unregistered. Employee is a salesperson and does not have access to records, diagrams, plans, or other sensitive information pertaining to monitored, installed, or proposed alarm systems. Therefore, the employee is not required to be registered. However, this employee has been registered since March 14, 2016. Recommendation is to close.
Explain that now?
Yeah.
They are registered?
They are registered.
Oh, so the anonymous complaint was wrong.
Yes.
Okay.
Okay.
So they're saying they don't have to be registered, but they are registered. Which, the point, it doesn't really matter if they think they don't have to be registered. They are, the anonymous complaint was wrong in this case. So I make a motion to close.
Okay, we have a motion by Mr. Cockcroft to concur with our council's recommendation to close this. Do we have a second?
Second.
And a second by Mr. Roberts. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Let me make a comment. Going back to number 5, let's make sure in that letter that we're going to send the respondent that we certainly clarify that salespeople do have to be registered. It's very, very clear in our statute. Let's make sure that this respondent understands that requirement.
Documents needed to sell the system would be considered access to records and diagrams, plans, and sensitive information, just whatever they would have to prepare to consummate the sale.
Number 7.
7, 2017-090-981. It's an industry complainant alleging respondent sending a letter to a customer as an attempt to trick the customer into switching services. Complainant alleges letter falsely states that complainant is a vendor of respondent, that customers' monitoring will cease unless they have their system reprogrammed. Respondent explains that it was believed their company acquired the customer's account in 2001 as part of an acquisition by its predecessor company. Subsequently, the parent company separated its residential and commercial business. The letter was sent as a notification of the programming changes due to this separation. The letter is void of any specific reference to the complainant or of any switching to a new alarm provider. Respondent states that they were unaware that the customer had previously terminated their relationship and was currently being monitored by the complainant. Respondent states it is all a misunderstanding and will update their records. Recommendation is to close.
This sounds very similar to some of the door-to-door tactics that we've seen of someone coming in and saying that their alarm company has been purchased, or their monitoring company has changed, and they need to reprogram the system, where they go in and take over a system. Truly has nothing to do with the current alarm company that they're using. It sounds very similar to that, only in writing, it sounds like they're now trying to claim, well, it was a mistake. This complaint came from the customer, or?
Is that date correct, 2001?
Yes. This complaint came from the current monitoring company of the customer.
So the customer's current alarm provider submitted this complaint against against some other company, the respondent, that had sent a letter to their customer.
Yes.
It said they would be cut off unless they went with them.
Oh,
Says
the letter did not.
cease.
The letter did not say anything about cutting off their system. It just said that they need to reprogram, and if you didn't reprogram, then there could be some issues in the monitoring.
But the reprogramming would be with a different company than what they were currently using, correct?
Right, but based on that separation from the other company,
2001?
well, the separation was recent.
Go ahead.
The separation, or the residential and commercial separation, was recent. It was not in 2001. They believe that they had this customer since 2001, and somehow their
So for
records.
16 years, they thought they had this customer, and the customer is long gone with a different alarm company. So for 16 years, this company has been laboring under the misconception that they had a customer out there. They send, and we're just taking at face value their assertion that they thought that this was their customer. Like Scott, I'm leery of. I'm highly skeptical of that. Have we had any other issues, any similar issues with this particular company, the respondent company here?
Not that I'm aware of.
They don't have, we don't show any other disciplinary history.
It could have been an honest mistake, and I'll agree to that. But that what we're seeing here is a common practice to mislead customers into
It's kind of like
switching.
slamming your phone service.
It's kind of like slamming your phone service. Yeah, it's a common practice. I got a telephone call yesterday from some company asserting that they were my alarm company. Well, I happen to monitor my own alarm system, so I know that they weren't the monitoring alarm company. And they were telling me that my system had to be updated and all this baloney that a telemarketer does. And when I asked them for their state license number, all I got was this little click on. So anyway. What we're seeing here is a common practice to mislead alarm customers. Now, it could have been an honest mistake here. I would think at the very and since we don't have any record of other complaints about this particular company as a practice, then I would think at a very minimum we need to send them a letter of warning. I'll make that a motion that we send this respondent a letter of warning about this practice. And I would think that if we have any recurrence of this with other customers, we need to look into it much more deeply.
That was one thing I was going to add. Would it count as a first offense if we do just a warning? If we should see this again, so we could do a more stern.
A letter of warning could basically considered a first offense, I would think.
So legally, it's not something that will be reported on the disciplinary action report. It is certainly something the board can consider should this case come back, should this respondent come back to you for the same allegation.
Y'all still have the ability to flag companies in the computer for similar activity?
Yes, ma'am.
So would that be an option to flag this entity?
I can put a flag on it just to say if we get another complaint, we would come back with the complaint, and then we would tell you they've had to form or action, which would have been just a letter of warning. We would do that automatically anyway. As you can see, we tell you if they have any other
I like
The other
Ken's
complaints.
language before, a stern letter of warning. I mean, I like that language a while ago, not just don't do this again, but to let them know that there have been similar complaints against other companies and it's not taken lightly by the board, and kind of get their attention and have it flagged, because if they continue to do this, then more serious action could be taken.
Was there any contact with the end user to know if this customer really ever was one of their customers? And how long ago? I mean, were they really one in 2001? Or
That might be really hard for a customer to discern.
they ought to know if they've been with their current company for 3 years or 30 years. Or
16 years. Yeah. The customer may not be aware that there'd been a change in the monitoring companies that had been sold or some such. Let's give the respondent here the benefit of a doubt, and at this point perhaps assume that it was all a misunderstanding, which is what's stated here. But we need to send them. I make a motion. We send them a letter of warning that would make clear that if this is some sort of an ongoing tactic to mislead customers, that we would deal with it appropriately.
second.
Okay, we have a motion by Mr. Roberts to send this respondent a letter of warning for against this type of activity. It was seconded by Mr. Cockcroft. All in favor, voice by saying aye.
Aye.
And then the flag comes automatically. Next.
Number 8, 2017077261. Complainant had their alarm system updated and believes there was a 2-year contract with the respondent. During the first year, complainant alleges that the alarm system did not work properly and the respondent would not fix the issues. Complainant eventually switched to another provider. Complainant alleges that respondent continues to harass for the cancellation fee, which is 80% of the contract's remaining balance. Respondent alleges that complainant waited 1 year after alerting them about any issues with the system. The issue involved a low battery reading on her 4 sensors. Respondent explained to complainant the process of replacing the batteries and resetting the system. A week later, complainant stated the issue had not been resolved. Respondent told complainant that they would send a technician, however, there would be a $35 trip fee because the issue was not a matter that generally involved the assistance of a technician. Complainant refused the technician and threatened to cancel the contract. Complainant called a few more times for other issues that were resolved over the phone. Respondent states that complainant called to cancel at the end of September 2017, 14 months after the contract was signed. Respondent further states that a welcome call is performed to all new customers with a customer service representative. These calls are recorded and ensure the customer understands their rights under the agreement. One question is whether the customer understands that the agreement is for 60 months. Respondent alleges that complainant responded yes and also understood that respondent was not affiliated with her previous provider and that she understood the cancellation clause of the agreement. Respondent has proposed a resolution of terminating her existing contract with the new provider and allowing respondent to continue monitoring their complainant's system, waiving all late fees, or if she remains with a new provider, offering complainant find another customer to take over her contract to avoid the cancellation fee. Recommendation is that this is a contract dispute and should be closed.
So the complainant changed from the respondent company to another company?
Yes, she has, and now it's more of a cancellation fee issue.
Was her contract only a monitoring contract, or did she have a service agreement? That would be where the $35 trip fee would come in, whether she wanted to pay it or not. It should be included if she had a maintenance agreement.
I believe she did not have a maintenance agreement. It was just monitoring.
$35 trip fee to me sounds low. I mean, it could have even been that a service agreement called for a trip fee on something.
Yeah.
But it does sound like it's a contract dispute. It's not. It's really alleging improper activity or anything we would have any say over.
The only thing I was trying to clarify is that the complainant is the one that actually changed services. The company, alarm company or monitoring didn't change her and extend her contract or his or her contract. This is something that they did on their own. They canceled and went with another company.
The complainant
The
canceled
complainant, yeah.
the respondent's contract.
The respondent didn't move them to somebody else unknowingly to the complainant. The complainant changed.
Yes.
That's what I wanted to make sure was clear, yeah.
Yes.
I agree, it's a contract dispute.
And it looks like the respondent had tried on several occasions to respond to the customer's problems, help them reset the system. I find no problem with what the respondent has done here. Madam Chairman, I make a motion that this particular complaint be closed.
Second.
Okay, we have a motion by Mr. Roberts and a second by Mr. Cockcroft to close this on the council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. Number 9.
Number 9, 2017-078-531. This complaint was opened by request of the board in the December 2017 meeting after hearing the previous complainant 2017-057981. Complainant alleged that respondent was performing an upgrade to a hospital's fire alarm devices on 8/28/2017 and that respondent was unlicensed. Respondent responded to the previous complaint and stated that they were not installing the system, only furnishing materials for the installation. An investigation was requested. The investigator determined that a licensed company, respondent in this case, had employed 2 individuals to perform the work. One of the workers is listed as an applicant and one is not listed at all. Respondent states that he never received any paperwork back from the state on the missing applicant. Respondent stated that apparently the paperwork must have become lost. Both applicants have been properly registered as of January 8, 2018. The recommendation is authorize formal and send a consent order with a civil penalty in the amount of $1,000 for employing unregistered employees in violation of TCA Section 62-32-312.
Madam Chairman, I make a motion we concur with the recommendation of our council.
Second.
Okay, we have a motion by Mr. Roberts, a second by Ms. Jones to concur with our council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. Thank you. Next.
Number 10, 2018-005431. Complainant believes he was being charged an additional $10 per month for a warranty that was to be included in the $36.99 per month billing, making the contract fraudulent. Complainant provided a copy of an invoice that shows he is billed every 3 months. If divided by 3, the total charges break down to $26.99 per month for service, $10 per month for warranty, and a $3 service charge. The contract provided by complainant states as follows. Number 4 is monitoring charges. Monthly monitoring charges of $36.99 plus applicable sales tax. Includes parts and labor warranty and is payable in advance and shall be paid quarterly. If paid quarterly, an additional service charge of $3 per quarter shall apply. Recommendation is to close.
not sure I understand the nature of the complaint here.
I think it's basically a math issue.
The arithmetic doesn't work. Because if you take the $26.99 and add $10 to it, that's $36.99, and $3 service charge, which appears applicable here, would make it $39.99, and he's only being billed $36.99. Sounds like he's being underbilled.
It's actually, it adds up to $36.99 per month, and it's billed every 3 months, so it's $113 something plus the $3.
So they obviously wanted him to pay annually, but since he chose quarterly, it's going to cost him an extra service charge.
The service charge is actually 1 month. It's
Right.
$1 a month.
So he's paying, so
Yeah.
he had an invoice for $113.97, which
Yes.
equals the $36.99 times 3 plus the $3 fee.
So what's the nature of the complaint?
I think it's a math issue.
He feels like he's being charged an extra $10 a month, but he's not. They broke it out as $26.99 plus $10. His
Not
agreement
calculated.
said it was $36.99.
Billing shows the $100 something for the $26.99 times 3, and then it states out $10, $10, and then the $3 service charge. So he believed that he was being charged more on that warranty, of the $10 warranty.
We have a motion in this.
Madam Chairman, I make a motion we concur with the recommendation of our council and close this particular complaint.
Second?
Okay, we have a motion by Mr. Roberts, a second by Mr. Cockcroft to concur with council in this matter and close. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Number 11 is being removed from the report.
Madam Chair, the next one, this is cases to be represented. It starts with Ashley's, but she's been called out. Can we perhaps take a break?
Certainly. We'll take a 15-minute break. We're going to call it.
Excuse me, when my boss walks in, calls out the attorney, we need to take a break. Especially when the next one has.
Are we finished? Or are we through?
We're ready anytime you want.
Okay.
I'd rather be through than finished.
Well, then I will make sure we're both. And I'll dare not say all mine's clear because we'll be here forever. Okay, we're going to go back on record and call our meeting back to order. Okay, where were we on the legal report?
We were at the represents, so I'm at number 12, 2017-059-721. The complainant was seeking a refund after entering a contract with respondent company. At the December 2017 meeting, details were unclear as to complainant's relationship with respondent company versus the authorized dealer. The board requested additional information regarding the settlement of complainant's account. Complainant signed a 3-year agreement with respondent's authorized dealer, allegedly including a money-back guarantee. Complainant stated that she was billed for monitoring services and blocked her credit card in order to stop payment. Respondent indicated that complainant contracted with an authorized dealer. Excuse me. Respondent reached out to complainant prior to submitting a response to determine if any assistance could be offered. Respondent stated that complainant's reference to a money-back guarantee is one offered by respondent company as a warranty on equipment. Complainant's issue is with the contract and not the equipment. Respondent stated that complainant's payments were alleged unauthorized withdrawals completed as automatic deductions. Respondent stated that complainant paid the remainder of her contracted amount to the authorized dealer on October 7, 2017, and the contract was subsequently canceled. Respondent stated that complainant paid her final invoice and no further monies were owed. Respondent also forwarded the complaint to the authorized dealer. The authorized dealer indicated that once a security system is installed, the contract is purchased, billed, serviced and maintained by respondent company. The authorized dealer stated that complainant system was installed on February 27, 2017, and there is a 6-month guarantee. The authorized dealer stated that complainant reached out in March regarding her billing, but only in September to place a cancellation request. The authorized dealer stated that they will not issue a refund to the complainant, as the contract indicates that the company will be allowed to resolve the consumer's concerns. The revised recommendation is to close. There were no violations found regulated by the board, and upon further investigation, complainant's issue is a civil matter.
It does sound like it's a civil matter, but I'm confused on all of the facts. Is they state it was a 3-year agreement, but yet they're saying it's paid in full at this point?
Right, apparently there was some conversation between the complainant and the company, and I guess they told her in order to cancel the contract, she had to pay the balance, and she did, and so now she's seeking a refund of what she paid.
I think it's unfortunate that we can't really do anything if there was a money back guarantee and they're not honoring that, but that is a civil matter. It's it's out of our control. Thoughts from the board?
Seems to be a civil matter to me.
I agree with Scott. I think that any remaining issues here would be a civil matter. It's unfortunate that in order for a complainant to pursue this as a civil matter, it would probably cost them far more to pursue it than they would ever get out of it. But viewing it as a civil matter, I think our recommendation to close this would be appropriate. So I'd make a motion we concur with the recommendation of our council and close this.
Second.
Okay, we have a motion by Mr. Roberts, a second by Mr. Cockcroft to concur with our council's recommendation and close this as it appears to be a civil matter. All in favor voice by saying aye.
Aye.
All opposed? The motion carries.
Case number 13 is 2017-047-211. This case arises out of an industry complaint alleging failure to register employees. Respondent is a large national cable, internet, and alarm system provider. Complainant went in one of respondent's retail stores and asked the sales rep if respondent, quote, sells systems from the store or if they send a salesperson out, end quote. Complainant alleges that sales rep said that respondent, quote, sells alarm systems over the counter based on information provided by the customer, end quote. Complainant alleges that neither of the sales reps he spoke to were licensed. Nothing in the complaint alleges that the sales reps had access to records, diagrams, plans, or other sensitive information pertaining to monitored, installed, or proposed alarm systems, which would require registration pursuant to 6232-312A. The original recommendation was to close, as the sales reps were retail employees and not required to be registered with the board. pursuant to 6232-305-4 and 6232-312A. At the time, the board deferred the decision and asked for an investigation to be considered at the December meeting. I will just state for the record that the investigation was still ongoing at the time the December meeting came on, which is why we're presenting it now. The new information: upon request, an investigator made an unannounced visit to one of the respondents' locations and observed a kiosk containing brochures for respondents' home security systems. The respondent explained that when a customer expressed interest in the home security system, the contact information was entered into their computer system and referred to a licensed technician for continued discussion and, where necessary, installation of security systems. Respondent again denied any misconduct and indicated that all sales, design, and/or subsequent installations are the responsibility of licensed technicians. The revised recommendation again is to close.
Is there reason to believe that the company involved, as the respondent here, has adequate licensed technicians to? Not an issue. Okay. Madam Chairman, I make a motion that we concur with the recommendation for council and close this representation.
Okay. We have a motion by Mr. Roberts. Do we have a second?
A second.
And a second by Ms. Jones to follow our council's recommendation to close. All in favor, voice by saying aye.
Aye.
All opposed.
Opposed.
Okay.
Chief Stewart drew the short straw today, so he will read case number 14.
In its entirety.
Number 14 is
Oh, my
2017-012-181. This was presented in April 20th, 2017 board meeting and was read on the record. This summary is quite lengthy. Is it okay if I just read the new information and the new recommendation?
Give us a chance to read whatever it is in the background.
sounds like it's resolved.
It has been resolved. I can read the new information into the record. And the new information on 2017-012-181, the respondent never received the original complaint from Tennessee, or it may have been lost since this complaint was transferred from another state to us. Once we contacted the Tennessee qualifying agent, he directly handled this matter and provided all the necessary information to indicate this matter has been satisfactorily resolved for the complainant by the respondent. The respondent credited the complainant's account the amount of $127.80. The respondent also personally apologized and made sure that the complainant was satisfied with the resolution of the issues. The complainant is satisfied with the resolution of the complaint. New recommendation is to close.
I'll make a motion to concur with council.
Second.
Okay, we have a motion by Ms. Jones and a second by Mr. Cockcroft to concur with our council's recommendation to close. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
That concludes the legal report. Thank you.
Thank you. Okay, next on our agenda are the appearances.
All right, pardon me, I'll handle that, but the appearances that we have are 3, and these individuals are not here. So I would like to move down to Mr. Hector Torres. Let me get...
What file is he under?
He is Exhibit F.
Okay.
Shauna, pardon me, has already handed out the information. Here because he sent me an email. And in that email, he was asking several questions. Dear Alarm Contractors Board, our branch management is exploring making some changes to our organization. In preparation for these changes, will our security and CCTV team require a separate license holder, which is qualifying agent, or will the designated qualifying agent have to add those classifications to his or her license? In addition, they would like to have the board's official interpretation of the following law. And actually what he's done, I broke it down into 3 sections. That's number 1 question he's asking. Second was that he wanted clarification of your statute, Part 3, 62-32-304. B, no person shall do business under this part unless the business entity has in its employ a qualified requirements for licensing by the board and who is, in fact, licensed under this part. The qualifying agent who is licensed under this part shall be in management position and be responsible for overseeing the quality of operations of the alarm systems contractors. And number 3, additionally, they need to know the difference in liability on the alarm systems contractor versus the designated qualifying agent. It's several questions here, which some I could answer, but I thought it would be best perhaps if he came to the board and explained himself.
Okay. Well, we have a fairly new management team. They just do not. Yeah, like I said, we have a fairly new management team. They just do not know the laws, statutes that we abide by. So I'm just looking for clarification because they are looking to make changes. And clarifications, of course, would be the official interpretation.
You'll have to push your button, Mr. Torre, or hold it while you're speaking. Thank
Now, this system was installed on low bid.
All right.
There's one button on there you can just hold.
Well, that's what I told him, but it's still going
Yeah, it
off.
still goes off. We good?
You have to, I think you have to
You're
continue to
okay
hold
now.
the button if you're just going to press the
Yeah,
button.
just talk real loud.
Okay. So I would like to have the official interpretation of Tennessee Code Annotated 62-32-304.
I think the problem probably with some of this is that we could each give you our individual interpretation, but we've got to give you a group interpretation. I don't know how we do that. How do we just?
Well, we're going to actually go and quote the statute. It does say that the individual has to be in a management position.
Does it also say full-time employee of the company? I think it does.
Let me kind of address this. Excuse me. To give you the underlying philosophy of a qualifying agent. First of all, I want to thank you and express appreciation for you to come before the board to try and understand the statute. I think it's highly commendable. We have too many people who just go blindly on doing their own thing until something goes wrong. So I really commend you for trying to understand the statute and making whatever changes you may be making. Let me give you kind of an underlying philosophy of the qualifying agent. When the statute was originally passed and continuing on, we felt it is vitally important to any company that there be some assurance that the company had people qualified to provide the services that they were offering, whatever they were, closed circuit television, burglar, whatever. The way in which the statute attempts to do that is by designating a qualifying agent, and the qualifying agent is a person who has demonstrated through experience and by taking examination that they know what they're doing. They, in turn, are supposed to be responsible for overseeing the people that are actually doing the installation. We didn't feel like it was necessary for every employee to be a qualifying agent because there's certainly experience requirements and examination requirements. But somebody needed to know the business and know what was being done and to make sure that it was done properly. So the whole statute is kind of, I say the whole statute, the bulk of the statute focuses on trying to achieve that. Now, with that understanding, let me maybe I can address some of the issues, some of the questions here. Qualifying agent can multiple sales office branches. The answer to that is not. The concept is that each operational area would have a qualifying agent that is in a position to know that the business is being done, the installation is being done and done properly, and that's the reason behind that. When we refer to a designated and we have qualifying agents and designated qualifying agents, and that may seem a little bit confusing, but a company may have more than one qualifying agent. In fact, that's not at all uncommon. But we felt like that one person needs to be designated as the qualifying agent, hence we use the term designated qualifying agent, so that if there are some complaints or problems or something, that's the person that the board can go back to and say, okay, you're the person who's supposed to be responsible to make sure that this was done correctly. Now, when we talk about in a management position, there's a little bit of flexibility in that. The statute requires the designated qualified agent to be in a management position in that they are responsible for seeing that the installations or the work is done properly. Doesn't necessarily mean they have to have the title of a manager. They don't have to have the title of an officer, but they're the person that is responsible to make sure that the installations are done properly. Now, let me try and let's see. Organization has different teams, different management, sales service. That should not be a problem. Each team would not necessarily have to have a qualifying agent. We look at the qualifying agent as being responsible for an area location. If you've got a business here in Nashville and you've got another one in Memphis, then there would need to be a qualifying agent for each location. Let's see, some of the other questions. Difference in liability between the alarm system contractor and the qualifying agent. Actually, both have responsibilities, and I'm going to refer to that rather than use the term liability. Liability carries maybe some unpleasant connotations that insurance companies like, but responsibilities. Right. The company has responsibilities, and the qualifying agent has responsibilities. The designated qualifying agent's responsibility is primarily to see that that the installation is done technically correctly. Now, we look to the designated qualifying agent to make sure that the company is fulfilling its responsibilities. Give you for an example, qualifying agent is a person we look to make sure that the company is hiring only registered employees or registers their employees. So they each have responsibilities in that regard. Is the qualifying agent required to report non-compliance with the items discussed above? And probably the best answer I can give you there is yes. Now, the reason, and I'll qualify that just a little bit, qualifying agents have the responsibility to report any violations that they are aware of, or probably should be aware of, but any violations of the statute that they become aware of, they are obligated to report that, whether it's their company or somebody else's company. As an example, if I see XYZ company out installing alarm systems and I recognize that there's some violation there, then I have an obligation, and it's more than and it's a very real responsibility and an obligation to report that. That's in there intentionally, because I know in the past people are reluctant to rat out somebody else. And I guess especially if it's your own company. If I were a qualifying agent and my company was not doing something correctly, then my first attempt would be to try and get the company to do bring it to their attention, make sure they're doing it right. If that failed, then there is an obligation for them to bring that to the board. Now, I don't know that I have addressed all of the issues here directly.
To have a separate classification.
It can be done either
Bullet
way.
point number 4, address that.
4, does the security and CCTV team require a separate license holder? They don't require a separate license holder, a separate qualifying agent.
To have separate classifications on their license.
Yeah. For instance, I have a qualifying agent that would classify me to do burglar alarms and closed circuit television, for example. So we don't have to have separate people. Don't have to have 2 people, one for burglar alarms and one for closed circuit television. So one qualifying agent in an office or an area office can hold more than one classification. They can have any of the 4 classifications.
Does it have to be one designated for a company, or could there be one designated for Berg, one designated for? One designated. It does have to be one.
Yeah, one per company. You don't have to have one for each.
But if you wanted to have one for each, you can't do that. Then you're saying.
Yeah, you could.
You can, I believe you can in your company, but you're going to have to tell me who the designated qualifying agent, because we're only going to hold the one person responsible.
Right.
We have to have one for each branch, each separate location.
One designated.
But you could have a qualifying agent that have the certification in one category, but your designated qualifying would have to have all of them if your business covers all of them, correct?
Yes, you can have 4
Multiple
qualifying agents.
but one designated.
Let's see, you can have 4 qualifying agents to cover those 4 classifications. But your designated qualifying agent has to be in the same classification that your company's in. Well, if that was 4, it's got to be 4.
So the
That makes sense.
designated qualifying agent does have to have all categories for the company.
Whatever the company, yes, sir. The company could have two. He has to have at least two. You could have all four,
Right,
but you
under-
have to have the two.
Right, I
Whatever
knew
the
you could have
company is.
more. I actually thought that you could possibly have a designated qualifying agent that covered Berg and monitoring and another one that covered fire, but I guess that's not the case. It is just one for the
But you
designated.
technically can, but for the office purpose, it only takes one designated qualifying agent.
She just
For your
has one.
company,
She just
you
has
got
one person
square.
to tag.
If the one person didn't have a particular category, like let's say their designated qualifying agent was licensed for Berg, fire, and monitoring, but they didn't have CCTV, and they had another person that did have CCTV, would that count for them to be licensed as a company for
yes,
CCTV?
he could. You have two, but you still have to tell me
Which one's the main one?
That I'm going to bring before the board.
Okay.
Who am I bringing in before the board?
So you could do it either way then of what's your question. You could have one that does all of it, or you could have separate ones for different categories.
Okay, I'm confused now. It was my understanding in 1990 when I first got my license that each branch had to have a qualifying agent, correct?
That's correct.
A designated qualifying
And
agent.
that if he had all the classifications, I only had Berg, and we're all in different cities, and she had CCTV, that I couldn't operate CCTV because I only had Berg, and she was in a different branch with CCTV, so therefore she couldn't do alarms. Does
That's
each
correct.
QA need to have each qualification on their license if they're going to engage in that business out of that branch?
I think we're talking about two different things.
I do
We're
too.
talking about multiple branches or multiple QAs at the same branch.
Well, that's the way I'm reading his question. Does our security and CCTV team, which I'm thinking that teams maybe operate out of different locations?
Right out of our
Well, I
office.
think if you start with number one, can a qualifying agent cover multiple sales offices and branches? I think we've answered that as no.
No.
You have to have a qualifying agent or a designated qualifying agent for each branch. Okay. That branch is only allowed to do installs, whether it be fire, CCTV, or whatever, if your qualifying agent is qualified in those classifications.
Designated qualifying agent?
No, not necessarily the designated
Okay, that's,
qualifying
okay.
agent.
But you got to have either a qualifying agent or it could be your designated qualifying agent in that particular branch that has the certification for fire if you're going to do fire out of that branch. You can't rely on the QA over in East Tennessee that may have the fire certification or classification to do fire installs in Memphis, is what we're saying. While it's one company, each branch has to be looked at individually as to what your installs are going to be. And if you have people in a qualifying agent or a designated qualifying agent position that covers the type of installs that you intend to do. Now, if you're not going to do monitoring, then, we're not going to make you say, well, you have to have a QA or a DQA that's going to be have the monitoring classification if that's not part of your business model.
And
But if
that's
you're going to
talking
do
about-
CCTV, fire, and Berg, then yeah, somebody in there has got to have those three classifications on their license.
And the monitoring classification is strictly for the actual central station. If your branch can sell monitoring and have monitored customers, and you don't have to have the monitoring.
But don't fall into the trap that some companies have done and contract with a company to do your monitoring that is not licensed in Tennessee. You've got to do your due diligence that whoever you're going with your monitoring, if you're not going to do the monitoring, is licensed in Tennessee to do monitoring.
Mr. Torres, do you feel like we've answered your questions? Maybe you have some situation that is still perhaps unclear that we could address that would help you understand.
We have multiple management tiers. So, and we have a sales manager, We have a person that's in charge of all the service and a person that's in charge of all the installations.
Let me back up and ask you a question. How many locations?
I'm only speaking of ours locally.
Okay, one location. All right. So you've got multiple management teams.
Correct.
As long as you have a qualified agent, there would be a designated qualifying agent in your branch that would be qualified in the classifications that you're providing services, then you're good to go.
That person has to be the person who's overseeing and ensuring the quality of the work.
Reasonably so. That doesn't mean he or she has to go out and look at every job, but basically we look to that qualifying agent, designated qualifying agent, to make sure that the quality of the work is what it should be.
And you would need one in each branch.
Correct.
If he's just dealing with
In
one
the state.
branch, then
Right.
Yeah, in the state, each branch in the state.
I think there's one exception as far as the location. We've had other cases where someone had like a warehouse or a sales office that was not open to the public, correct? That was like a satellite office of a branch, that location did not have to have a qualifying agent or be licensed.
Yes, we looked at that, like the warehouse, if you don't have a telephone that's being answered for customers, or you don't let customers come in and you sell out, if it's just a warehouse or storage area. Or you might even be having it to have your monthly meetings with your salespeople, but it's not open to the public.
You can even have a sign at the location, but
Yes.
they couldn't.
It's open to the public or do any selling out of that location.
but we don't want to confuse Mr.
That's
Torres with that. That's kind of an unusual exception. And but what you've outlined, you're going to have a location somewhere, either here or wherever.
As far as your management structure inside your branch, you could have several managers as long as if they are required to be registered employees, as long as they are registered for the statute purposes, yes. But inside that branch, as we've told you, if you're going to do fire installs, burglary installs, and CCTV installs, somebody in that branch has to have the certification through the state as a qualifying or as a designated qualifying agent in there that allows that branch to do those installs. And if you want to have qualifying agents and one designated qualifying agent, that's your prerogative. But, make sure all of your people, where they're termed a manager, that if they're required to be a registered employee, that they're registered. And those responsibilities fall back on your designated qualifying agent to ensure that all of your employees and their practices fall within the statute and are compliant.
The designated qualifying agent doesn't necessarily need to be a manager over all these people, but needs to have access to be able to go to any of those managers and say, look, we've got a problem here, we need to address this. And then at some point, the qualifying agent, would have to take it upon himself to step down as qualifying agent or notify the state, if they weren't getting that done, to be able to say, I'm not going to be the designated qualifying agent anymore. But I don't think that the DQA has to be like a general manager over everything, but they need to be able to approach all those managers.
No, you could have a manager over here, and you could have your designated qualifying agent over here. They don't have to be at the top of the chain.
So as long as they have the authority to make decisions.
They're kind of a compliance officer for that branch to ensure that all the practices and so forth, everything that's done out of that branch is in compliance with the state law. They're kind of like the civilian police over that branch to ensure compliance, or they're following the rules. They don't have to be a manager, they don't have to be a supervisor, but they have to be entrusted with the authority that if the manager is bringing in an employee that's not registered, they have to say, register him or her or get rid of them. That's their position, as a compliance type.
I don't see it here, but our TCA 6232, I don't know the rest of it, does say that you have to be, the DQA must be a full-time employee of that location. So with them being a full-time employee, then they're going to be able to check up on everything.
Mr. Torres, I would just offer to you, in addition to the statute, there are codified rules that kind of lay out more specifically, the responsibilities that Mr. Roberts and Ms. Hickson have set forth for you. So whomever you choose in those positions that they've outlined, they should familiarize themselves with these responsibilities and requirements, and that's accessible online as well.
Appreciate it.
Have we completely covered you up with more information than you ever dreamed was available?
Just the right amount.
No, I mean,
let's-
do you have a better understanding, or is there an area? Because we have two attorneys here that if there's a question, now's the time.
Well,
Ask them if it's
when I've presented this Tennessee state law to my management team, I was basically told that it was very ambiguous. I don't read any ambiguity here at all on that. I read a lot of code, and for me, the word "shall" is a mandatory. Being able to describe what management actually constitutes would help them better comply with this.
You can have 10 managers in a branch if that's how your business model is set up. You know, that's not our concern. Our concern is everybody that's got access to information that requires them to be registered, that they be registered. And it depends on what those managers' responsibilities are, if they would have to be registered employees. And again, that would be the responsibility of the DQA for that branch to ensure that everybody that has, we've seen it, I can't remember in the legal report, access to customers' name and information, plans, drawings, and so forth. If they're in that position that they're privileged information, then yeah, they're going to have to be registered if they don't ever do the first install, because they have access to that information. But, you know, as far as them answering to the DQA, not necessarily. They would have to, as far as conforming with the state regulations.
If I may ask, where would you be in this hierarchy? Would you be the DQA, over, under, or the DQA? Well, then you've got all the information you need, and you can go back and tell your boss what they need to do. You know, basically, I'm not trying to be.
No, I mean,
Tell him gently.
It's. I'm sorry.
Well, I mean,
I'm kind of
seriously,
straightforward.
When it comes to them conforming to the policies and rules and regulations, you're kind of like you're the boss over that area.
Yeah.
You may not be the boss over scheduling and installs and all that, but to ensure that the rest are following the rules and regulations, then yeah, you're the head of that. That responsibility falls strictly on your shoulders.
They may pay you, but you have to explain to them what they need to do to conform, whether they like it or not. And then I've seen times that QA's told their boss what to do, and boss said, and QA had to quit because they were going to get hit, fined, flagged, so forth.
Because it's rare, but there have been times when there were several civil penalties against the DQA.
Yeah.
But it's rare. Usually it's against the company.
Especially when you have a QA or a DQA that can show that they have tried in earnest to bring that company into compliance, and the other part of the management team just absolutely ignored them. You know, they worked people without them being registered. They were installing systems that they were not licensed to do. Then, you know, we always look at the circumstances, not just a blanket decision, well, we're going to hammer this QA. If that QA is tried, even to the point, like they say at times, QAs have had to leave companies because the company would not follow the law. And it comes back on you because it's your personal, you're the one that's taken the test and gotten these qualifications, not the others, the management teams or whatever. You have to think about your protection first to ensure that you're following the law and make sure everybody else inside is. You're kind of like a sergeant at arms, I guess you'd say, that you're the rule enforcer.
My guess is it would be very uncomfortable, but technically you could step down as the designated qualifying agent and not resign. You could send a letter into the state and say, I am no longer, as of whatever date, I won't be the designated qualifying agent. But that doesn't necessarily say, I mean, I would think the work situation would be uncomfortable then, but.
Well, they'd have to find another one.
Right.
Yeah.
Right.
But at least you wouldn't lose your license over something that they made you do.
Very
So
important.
Torres, do you see any problems with the situation as you visualize it now? Can we help you any further?
Not as of yet.
Just send them in if they need more help.
Well, I commend you for asking questions on the front end. I think certainly the board and I know from experience the staff are all willing to help clarify any situations that might come up. So if you've got something that comes up, you want some clarifications, I know the board and from experience the staff would be more than willing to try and help you to understand and comply with the statutes.
Do you have a copy of the rules and regulations besides the statute, the state laws?
Yes, ma'am.
That's your Bible right there when you go talk to these people. This is the word. This is what we have to do. And I'm the one that's entrusted with doing this. And then, like I say, if anything else comes up, and like all the rest of them have told you, reach out to these attorneys, reach out to the staff, because they can help you immediately, where we're just up here every other month if it's something that needs immediate response. But thank
Really
you for
appreciate it.
coming.
Thank you.
Thank you.
Hey. Where do we want to move to next, Ms. Best?
We have a representative for Electronic Security Association with us today. Would you like to come in and sign up Michelle Youngblood?
Yeah, that's whatever. It's fine.
Well, no.
It's all right.
You explained it. I'm mispronouncing it because it's misspelled on my sheet. That's the
So
thing.
it's Michelle Youngblood.
Youngblood.
Do we have a folder for her?
It's Exhibit E.
Okay.
Just the email that correspondence that we have back and forth. Like I say, she's from the Electronic Security Association.
She has a
Presentation.
It's not showing. Good morning. First of all, thank you for allowing me this opportunity to present to you. Appreciate that. I am the Vice President of Training for the Electronic Security Association. I oversee all training aspects and work very closely, obviously, with our chapter here in Tennessee, who delivers a lot of our training in this territory. So our request here is regarding how we proctor our online exams, our exams for online students. Currently, we are approved, and I'll click here. Our training is approved for several of the classifications for licensing. These are the courses: the Advanced Intrusion, CAT Level 1, our CFAD certification for fire alarm installation for fire as well, and our video system technologies for CCTV. We have the opportunity for these students to take these courses, the training online, and more people are doing that, obviously, with advances in technology and for convenience sake. So right now, our students go to third-party testing centers. We use PSI like you all do. And so once they complete the class, then they would schedule time with PSI, go to that physical testing location, and take their exam. This change we are proposing is to transition that to a web-based proctoring. So I know there's another training provider that has already presented to you. I'm not sure what the time frame was. And their system has been approved. So this is where I'd like to present our system. To back up a little bit, this is not the education program at the National Training School is governed by our education committee. So this is something that our education committee has been looking at and did vet very heavily. They approved this process back in June, but it took about a year of them being comfortable and understanding this process. So they did review it, and it has been approved by the education committee. So if that helps, so to clarify the process. And this is a broad overview of all the steps, but I understand the main part here is how does this process prevent cheating, right? So that is the number one thing we want to be an assurance of, is that the student is not going to cheat, because when you have somebody physically present, they can watch for things and check for things. So normally, like I said, they go to PSI for the online, but our instructor-led classes, the ones that happen here in Tennessee, that's an instructor. So the person who taught the class, then when it's time to take the exam, then gets that student, the students in the class, set up to take what we call it a computer-based test. So all the students are required to bring a laptop, log on and be authenticated to our learning management portal, and the test is then delivered to them that method, and the instructor is there to monitor that test and this testing that happens. The system itself grades the exam, randomizes the questions, so no student is getting the same questions at the same time if they're sitting beside each other. So this change, like I said, is just for online students. Nothing is going to change for our instructor-led delivered classes. The instructor will still proctor those exams. So this, the handout you have, the two handouts I've given you, explain what the ProctorU vendor, so this is a vendor we use, does to prevent cheating. And then the other one is explaining how the process works for the student. But just kind of quickly, so you don't have to read through all that, you can have it for your record. There's basically 9 steps to this process. And essentially the student completes the online course, and I'm going to dive in a little closer here to each of these steps. So the student takes and completes the online course. That all happens through the ESA National Training Schools campus portal site, so it's all online. My team then confirms that that student has actually completed all components and is eligible to take the exam. So we look at the time spent, so we get reports out of the system, and we have online quizzes. They're called gatekeepers, to confirm that they have went through the various components. So we confirm all that. So then they move on to step 3, which is we now provide the student instructions to register and schedule test time with ProctorU, so the vendor. So email is sent to the student following the completion confirmation. Then the student, for step 4, in between there, goes to ProctorU, and they set up a time with ProctorU to be proctored, so based on their schedule. So they arrange all that with ProctorU, and then ProctorU will notify us that that person is scheduled at this date and time. Once that's done, we set up the exam on our system. So the exam, the test questions, the test banks, all of the management of the test itself is still handled by the National Training School team. So we set in, we do passwords, we set time limits, we randomize the questions, everything. It's all still managed by the National Training School. The date and time of the test, so that comes along, and the student signs into ProctorU and completes the authentication and security process. So 2 things that are critical before even the test is taken is this the right person? Is that who they say they are? It's not somebody else going to sit for the test for them. And then also the security, so the testing environment. Exactly. Thank you. Good question. So I'm going to show you a video of how that works and what ProctorU, what we explain, and they explain to the student of what they need to do to be prepared. So before I show the video, this is web-based proctoring. So in order to do that, the student is required to have a web camera and a microphone. So that is a 2-way video that's going to happen. So I'll show the video. I don't know if I can run the mouse, but can you just click that video link there for me?
Hello, and welcome to ProctorU. Please have your photo ID ready. Acceptable forms of ID are a valid and current government-issued driver's license, state ID, or passport. You may also use the school ID from the institution you are testing with. All programs on your computer will need to be closed, unless they are an allowed resource for the exam. Your computer's display settings will also be checked to ensure that duplicate displays are not being used, as this is not permitted. For Mac users, the screenshot function will be disabled. However, your proctor will re-enable this function at the end of your exam. In the event that you experience technical issues with your system or network, we will provide you with personalized, expert technical support to help you get connected. Your proctor will need to see the physical screen of your computer, so please have a mirror or cell phone ready. This will be used to show the proctor around the edges of the screen. CDs, glasses, compact mirrors, or bread toasters will not be accepted for the monitor scan. Your work area needs to be clear of any clutter or materials that are not permitted for your exam. This includes the work area, the floor underneath your work area, and the walls. Your testing environment also needs to be in a private location, preferably at home, with no one else in the room. Public and outside locations are not permitted. The area should be well lit so your proctor can see you clearly. Your proctor will ask for a 6-point camera pan of the testing environment. This includes a slow pan of all walls in the room, the desk or table, and the floor around the work area. If you are using an external camera, you will slowly rotate the camera and pause at each wall for 2 seconds before slowly rotating to the next. If you are on a laptop, you will simply pick it up and follow the same instructions. You will be asked to show your cell phone and put it away before the exam is started. You will also be asked to remove any smartwatches or tablets. You will need to stay in view of the camera at all times during the exam. Your proctor needs to see you from, at minimum, chin to forehead during the entire exam. Keep in mind that talking or reading the questions aloud is prohibited during the exam. The allotted time for your exam does not begin until the startup process has been completed and your proctor has unlocked the exam. If your proctor changes during the exam session, this will not disrupt your exam and it will continue to be proctored for its duration. After notifying your proctor that your exam is finished and the logout process is complete, there will be a short survey that follows. Please take the time to fill that out, as your feedback is very much appreciated. Thank you for using ProctorU, and good luck on your exam.
So the key, as you can see, there's a multi-step process to ensure the environment is secure and the identity. So one thing to note on the identity is we set the requirements for what is a valid identity check. So for us, it is a valid, non-expired driver's license. So the same as our PSI testing centers, they have to bring that and show that. The student holds it up, and at that time, they actually take a picture. So ProctorU does capture that. So if there's any challenges at a later time, they have that. The other aspect of authentication that I find is really unique with ProctorU that I really liked versus other vendors I looked at was they use an open records quiz to confirm that identity as well. So if you've ever, sadly, I had to do this for driver's license in Texas, and yes, I got a speeding ticket, and I had to take, so I didn't lose, I was able to take a defensive driving class, and so there's questions on there that it's scary information that they know about me, like what car did I own this car out of these 5 cars in the past? Is this a past address of mine? So the public records, if you know what I'm talking about, they ask those questions. So if the individual can't pass those, because it's happened, then that person has to be rescheduled. So for the exam. So any questions on that identity authentication process that they use before I continue? Okay. The other, as I mentioned, the proctor that is watching them and getting them through this process and authenticating and securing their site, the proctor, they will then guide them to our learning management system where they log in and take our test through our system. The test is password protected. We call it a proctor only password, so that that ProctorU employee has we issue them that password, and that's how they then log in using their password. You saw through the video that they check different things on the students' computers. That's because they use a technology called Log Me In. It's software. If you've ever had technical support, sometimes they say, "Can I take over your computer? Check some things out." That's what ProctorU uses. So they can see the video of the person as well as watch what's going on or monitor what's happening on the computer system settings. So the student is in our system. They take our exam, delivered. Hopefully they pass. What happens after that is the student gets, "Congratulations, you passed." The same thing that currently happens with any of our classes is they get access to their certificate of completion. It's automatic, right? Emails get sent, triggered, reports happen. ProctorU also, we have a portal site through ProctorU we log into. We can see all these tests that are being scheduled, any incident reports. Incidents get emailed directly to myself and my operations manager, Tracy Dalrymple, if there's any issue. If then they call it an incident report, if they see that the student and they'll tell the student, "Hey, what are you doing?" or they have questions. But they start recording. So they hit record on that, and that's what the type of incident reports we get. The other component to this is ProctorU they have suggestions for proctoring and what's considered, violations of cheating, but they work with us. So we have a file with them that explains what we consider cheating, we are open book tests. So they say, "How do you want us to check that?" No loose papers. That's another part that, they use us for compliance. What would you consider? And when do you want us to stop the exam? It's all through what we have directed towards them. So that's basically the process. And then also the handout, like I said, it outlines, the one pager says, what do they do to prevent cheating? So do you have any questions for me or?
Like a pretty comprehensive process. I would have any questions.
What courses or what tests would this typically be for?
Yeah, thank you. Good question. So it'd be for the Certified Alarm Technician Level 1, the Advanced Intrusion Systems, the Video Systems Technologies course, and then the fire alarm installations methods.
So it's something that'd be used for employee.
Correct. Mm-hmm. Yeah, we train about 7,000 people a year through our program, and it is used mainly for getting a license, but then we also have companies that use it for their onboarding process. So yeah, it could be a lot of different reasons they take it. Is licensed.
I guess I was thinking about just for our standpoint of what we're considering it for.
Yeah, for here it'd be for licensing to get them registered. Mm-hmm.
Are you going to be adding more and more courses to this process?
Not at this point. For Tennessee at least. So for other states where we have additional courses approved to get to licensing, then yes, we would. So yeah, we're talking to Texas right now, and because we have a residential fire course that they require for one of their classifications. Mm-hmm.
But you're here today you're telling us about this to add this as a proctor method for courses that we've already approved? Okay. Sounds very comprehensive. I don't have other thoughts, but it sounds like it meets a lot of the requirements to me, if not all.
Do we need to?
You need to vote on it, but let me ask the board, all I put down was, is it for initial application, it'll be employee training like for level 1 and fire, whatever class.
That pretty well covers it, I would think. Doesn't it?
So it's not going to be CCTV going at Berg.
We'll let you level 1.
Yeah,
Okay.
and then fire is to the fire alarm installation methods for the installer, and I believe the certified fire alarm design certification, which is a whole nother that has a whole longer process than just take a course and a test. So yeah, there's a lot of
That was
stuff.
like
This
a
is only-
2-day test when I took it. So it would
It's-
be
it's-
long on the
It's
computer.
not, yeah. It's a years long process to get
Yeah.
certified as a level 3 fire. Mm-hmm.
And it's not changing the process how they take how they take the course. They had already been doing that online, but going to a proctored location.
Correct.
Taking a test.
So it's just changing that aspect of how they're testing.
Correct, yes.
For renewal, just application.
Yeah.
Initial, okay, that's what I'm making sure.
We don't have any proctored requirements for renewals, I don't think. I would think that someone could use that for renewal.
Yeah, that is the case. We have people use our core, we call it core courses, to get the continuing education to renew their license. And we don't handle it any differently. If you want to take level 1 and get a completion certificate, here's the process you need.
I think the bottom line here is that the board would, after looking at this process, feel like it's adequate to provide reasonable security for the proctoring the examination.
We
And a
would need
motion.
that form of a motion.
So we
yes.
do, that's what I was going to ask you, do we need a motion
I
or
would.
vote on it?
I make a motion that we recognize the process that was presented under that ESA has presented using ProctorU as an appropriate method of proctoring examinations to ensure their integrity.
Second?
Okay, we have a motion by Mr. Roberts and second by Mr. Cockcroft to approve the ProctorU process for administering courses, online courses as specified by the ESA. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. Thank you. That was a very interesting presentation.
Good job, well done.
Okay, next.
Well, we're just going to move right along because the appearances did not appear.
Non-appearances,
That's right. But we're going to go,
disappearances.
where is my, you have your monthly report for November and December of 17 and January of 18. It is still the same for all of 3 months. Karen Jones' license has expired, and Mackenzie Roberts' license has been expired.
Our license.
Not license.
I'm sorry. Just want to see if you were
About
listening.
Trying to tell y'all something, I believe.
No, it says
that
2
borrow
alarm
your
system
pen?
contract board and members' appointments have expired. I'm sorry if I made you nervous there.
We were nervous before you brought the point up.
Okay, so that is still in effect, and I have been instructed that they are looking to reappoint at any time.
Who's Robert Gribble? I've got that coming up on my monthly report.
What exhibit are we under?
You must have something else on your he's a funeral director. I mean funeral board director. You got an old something on your old
must have
on the
not deleted
iPad. Yeah, it didn't.
Oh, no,
delete
it's
it.
okay. It just says Robert Gribble. I couldn't. His name is under my the monthly report tab, and I couldn't figure out.
Yeah, when you,
strange.
yeah, when you close the tab, sometimes it says administrator.
Oh, okay.
Oh, that's okay.
Odd.
I've
It's gonna be
ignored
an
it.
Vacant, but we're
odd
still
day.
here.
So now are we going to the budget review, or is that?
Yes, I'm going to.
On that same note, mine has also expired, but they had contacted me as far as the reapplication process. Mine expired in December. You don't have me on there, but
Oh,
You
this past
don't
December.
look expired.
yeah.
It
My
also,
license isn't expired either.
speaking of Robert
It also
Ribble, we
says
don't
they're
have,
vacant.
Yeah.
Robert Ribble, he deals with expired peoples.
yes.
Give me just a moment here. I'm looking at something.
Mine was I was completing someone else's term, so it wasn't a full.
Oh, that's right, you took over.
Mr. Tucker's.
Yeah, Tucker.
Thank you for bringing that to our attention. We'll have that added to the report for January. All right, we'll move right along to the budget review. I do have some good news. Well, surprise!
Having enough
I
money
mean,
to
about saying it
last.
a minute ago.
Sorry about that. Your ending balance as of to date is $110,275. So you're not in the red.
That's a good thing.
Yes, it is. I've given you July 17 through December of 17, and you can see like we're staying pretty even across as far as our expenses are concerned. Your total revenue was $272,993. Your total expenditures are $162,718, which left you the balance of $110,275. So we do not have to worry about a sunset due to not having the amount of money to operate. The next thing we would fall under is application review, but I'm going to, if you don't mind, I'm going to move right on to the next one, which would be discussion. And we'll come back to the applications because I'm going to have to read you the other individuals as
No
well.
legislative update. Okay,
No, ma'am, there is no legislative update.
okay. So we're going
We're
to
go
the
right to a
discussion.
discussion, please, if I may. I received an email. Sometimes I receive these emails. I do know that I can respond to them, but then sometimes they're asking questions that might need to be put on the record, and I'd like to bring different things to you about that. So I'm going to have to read this email. Our company, Switchmate Home LLC, it should be on your laptop, if it's not. Huh? Okay. We're a well-known consumer electronic company, and our products can be found in retail stores like Walmart, Target, Bed Bath & Beyond, Lowe's, Home Depot, Ace Hardware, and many others. We have a new product line coming out this year that consists of a do-it-yourself home security kit complete with security cameras, window and door sensors, and the like, no alarms. All that can be removed from the box and set up in minutes without the need for any tools or wiring of any kind. Our products either plug into existing outlets or are battery operated. Customers can set up our product in minutes and be up and running immediately. If they would like to, customers can subscribe to an optional back-end monitoring service. We are using Rapid Response, and this company is a licensed monitoring company that we have retained to take care of that service for us. Customers who are interested in this back-end monitoring service will contact Rapid Response directly from information that they find in the retail packaging of the product they buy. They will have an account with Rapid Response, and all billing will go through them. We are beginning to apply for all of the licenses in the state of Tennessee, and we are not sure what we are required to apply for, given that they won't have any employees at all in your state. There is no need for professional installers of any kind. Our products require no tools or wiring to install, and that Anyone interested in back-end monitoring will have an account with Rapid Response, not with Switchmate Home LLC. As soon as I read that, it just sounds like any other thing you have. You go into the store, you pick up the box, you take it home, you put it together yourself. That doesn't require a license that I know of. My question is that a joint venture?
No.
They don't need to have a license in Tennessee.
Based on the information they've provided here, they would not require licensing in Tennessee.
All right, that is the response that I will go back and give them in writing.
But if they are receiving some sort of money or something from, are you making the assumption that they're just strictly referring them to Rapid, or?
Commission.
No, that would be the indication, but even if they were getting some sort of rebate, and I prefer that to kickback, if they were getting some sort of rebate out of Rapid Response, which is possible, I still don't see anything here that would require them to be licensed in Tennessee. Basically, they're selling a box.
When I first read it, that's what it sounded like. But then it goes on to sound like they're still their customers somehow, but they've chosen Rapid Response to handle that for them.
The first line of the second paragraph gets me. We have a new product line, blah, blah, blah. Do-it-yourself home security kit, no alarms.
Right, and they've listed three things that are alarms:
Door
cameras,
switches, window
windows, and
switches.
door switches.
If it's not an alarm, why do they call it home security?
But that's unrelated in the standpoint they can sell it, and if it's all a do-it-yourself install. I thought the same thing. I thought it was funny that they said no alarms, because there are, but they're excluded alarms, so it doesn't matter. But the monitoring would require licensure on their part, in my opinion.
Not if they subcontracted out to Rapid Response.
Well, even if they subcontract it out, if they have any access to who those customers are or that information, if they could take and move those customers to another central station, they should be licensed as a monitoring company.
Scott, I don't see that in there in what they're saying here. And I'm looking down to one of the later paragraphs. Let me see if I can find it here. They will have an account with Rapid Response. Let's see, banking up a sense for customers who are interested in this back-end monitoring. Service will contact Rapid Response from information they find in a retail packaging of the product. Basically, looks like they're going to provide a contract form that if you fill it out and send it to Rapid Response, then you can have monitoring on your system. I just don't see anything here that would require them to be licensed. This company, assuming the monitoring company would have to be licensed. But this company here...
would this system work with anything else besides Rapid Response for monitoring? Or is it like a sole source that if you want monitoring, you have to go with Rapid Response?
Probably would have to go with Rapid Response.
If you have a problem with the equipment, what kind of licensed technician do you call to answer questions or come out and fix it for you?
I don't think you'd be calling this company.
Right, I don't think they have any. I don't think they'd send anyone out. They might send you a new box of equipment.
Yeah.
Yeah. That's
But they've got to have a tech line. They've got to have somebody to answer a question. Why doesn't this?
Even if they did, though, that wouldn't require licensure from the.
Isn't this
installation
basically? And I'll
standpoint.
just name the name is. How different is this from Simply Safe that I see advertised on television?
I would not see any significant differences.
That's what
The
I was thinking.
significant difference in this and Simply Safe is Simply Safe does actually do all the billing, and should be licensed, in my opinion. This one does have a new approach where they are not going to do the billing. They've probably done that on purpose. It's a very fine line there as to whether or not they still own those accounts or not. Do they have any financial interest in it? Could they get information? Could they log in and see who's on the call list, who the password is, or what the password is? Could they move it to another central station if they didn't like their relationship with Rapid Response?
They would just start putting different literature in their box, telling them to call Rapid Go Get 'em instead of Rapid Response.
Most likely, taking this at face value, they would not have to be licensed. But your example of the other entity, they do the billing and collection. They're actually selling the monitoring, and I think they should be licensed.
Well, then why are they not licensed? No, I'm
Rapid
talking,
AT&T,
no,
yeah.
no, no,
The
no.
other one company
Simply
is not.
Safe.
I'm talking about Simply Safe. If they're doing this, why aren't they required to be licensed?
That's why I brought it to
While
you
you're
because.
before the board.
Oh, Simply Safe, excuse me.
I would suggest we open a complaint against them.
Yeah, I
Oh,
mean-
well, we're getting off track here.
No, we are for the, I mean, if this company, I agree with Scott, if they're hands off after the customer buys the box, my only thing is this a sole source that you can't have monitoring unless you go with rapid response? I have an issue with that, I have to buy your security system, but I can't go with ABC monitoring. I have to go with rapid response because then you do have a joint venture. If you want your system monitored and that's your only choice, then you have a joint venture with the monitoring company. You're selling the system, but you're forced to buy their monitoring, to have monitoring.
My guess would be the systems are pre-programmed, and they would be programmed to rapid response only. Now, it could be handled otherwise, but my guess is it's pre-programmed to rapid response in some fashion.
Which you could almost make the argument that just that information, the pre-programmed information of the number to call and the account number is,
It's a
well,
joint
no,
ven-
not joint venture, but that in
It's-
and of itself is the information. What is it listed in the it's confidential information that they shouldn't have access to if unless they're a licensed company.
But is this home switch or whatever it's called, are they going to have access to that? Or when you fill out that card, are you from that point on dealing strictly with rapid response?
We don't really know from this response. It sounds like from this response that they wouldn't, but why would they, if they don't get anything out of it, why would they be
Advertising
pushing
for
them
'em.
to go to rapid response?
You wouldn't be able to sell the system unless there was nobody would want it unless there was some possibility of having it monitored.
Yeah, but you could have choices. You could have choices in monitoring versus saying, if you buy this system, your only choice is this company.
Now you know why I brought it to you. Thank you.
Well, I think you need to email them back and say, we have issues with the following things. ABC, answer these, and then we'll move forward. Yeah.
It would be my opinion that as presented, this would not require licensing in Tennessee. They have no employees in Tennessee. They have no operations in Tennessee. The monitoring is by a licensed company. I don't see anything here that would require them to be licensed. Now, that's not what I would prefer, but nevertheless, that would be the way I would see it.
Ashley, define joint venture.
Joint ventures are usually when two companies, for the most part, pool their resources to kind of create another company, and they're both benefiting from that. When Cody and I discussed this, I didn't see that here. I didn't see that Switchmate and Rapid Response were coming together to do that based on what was laid out here. I didn't see a joint
What would
venture.
be a joint venture in the alarm industry?
So if your company and Ms. Jones's company decided we're going to do this and target this particular area, these hospitals or whatever, under this company name, Scott Karen, that's a joint venture because you're both pooling your resources, you're putting your capital together. You've essentially created another company using the best of both of your companies.
What if one company subcontracted another licensed company?
So that wouldn't be a joint venture, that would be a subcontracting issue.
So you're saying, because it references a joint venture to circumvent the law, and a joint venture between two licensed companies is not doing anything to circumvent the law. This is a licensed company and an unlicensed company, which is what it specifically says, is that you can't have a licensed company go into a joint venture to circumvent the law.
Right, and a joint venture would not circumvent because, say Karen was licensed in Bergen Fire, you have the alarm. You're going to pull your sources together to create a company that can offer all of those. But if Switchmate doesn't have any of that and they were joining with a company that had all of that, that's a illegal joint venture for our statutory purposes.
Why wouldn't it? Isn't that what they're doing? And they're joining with Rapid Response for Rapid Response to be able to offer the monitoring that they're not licensed for.
To create an alarm system for someone.
But when I read it, I didn't see it as them joining with them. They're giving them, you can use Rapid Response. Again, we don't know if that's a sole source. That's the only place that this system would work for.
That's one of those things that when you email them back, ask them if the customer purchases your product, does the customer have to get their monitoring from Rapid Response, or do they have choices? And if they answer back and say, our monitoring will only work with Rapid Response, then the customer really doesn't have a choice. They're being forced into a relationship for monitoring with this company that they've designated.
Wouldn't any sort of financial gain by either one be a joint venture? I mean, if an unlicensed company is getting any financial gain out of the licensed company doing something, whether they pay them a finder's fee, whether they pay them something to put that advertising in with the box with it.
They're selling the product. That's a gain, financial gain.
We don't know that.
Right.
But why would they do it if they didn't have some sort of financial gain out of it?
I do not have an answer for.
That you can ask.
Absolutely.
They're making their money?
They are,
Financial
but
gain.
but they're also then selling something else out of the box. You know, it's fine for them to sell the box, and they must know that there's some issue, or they wouldn't have asked.
But it goes back to when you put that card in that box, it says if you want monitoring service, you have to contact Rapid Response. It doesn't give you any options.
Right, so it sounds like the question is this a sole source or is it a preferred referral, for lack of a better phrasing? Like,
But-
we suggest Rapid Response versus ABC monitoring. If that's the case, are you guys okay with them proceeding non-licensed?
Well, if you look at the first paragraph, they said our products can be found in retail stores, Walmart, Target, Bed Bath & Beyond, Lowe's, Home Depot, Ace Hardware, and others. They're selling boxes. They're selling it across the counter. I see no reason for them to require licensing. Now, the monitoring's being provided by a licensed company. That's the way it should be. If there's some sort of financial transactions back and forth between Switchmate and Rapid Response, then it still doesn't require Switchmate to be licensed.
This is very similar to something that was brought to us by, was it James Beatty with Lowe's?
Yes.
And for Iris, and we told him he needed to be licensed as, and he was doing the same thing, where he had a monitoring company that was doing all the back end.
They were doing the billing. That's the
Right.
difference there. Lowe's was doing the billing, and that's what we told them. If they did not get if they were not involved in the billing for the monitoring, then they could sell it out of the box but they were not, they wanted to handle the monitoring too, which in a way is similar, except this company's not doing the billing, but they're still partnered with a particular monitoring company.
We need to know if Rapid Response is given Switch of kickback, for the less of better words, to send them customers. And then they
I think the question is, are you limited to Rapid Response for your monitoring with this system, or do you have options? I don't know did Lowe's ever apply for their license, or did they let it go?
Let me ask a question. If they come back and say, no, you're not restricted to Rapid Response, are they required to be licensed or not?
I would say no, because you're not mandated to.
Okay, now, on
If
the,
I can go to ABC and get my monitoring, then, and it'll work with that system.
okay, so under that scenario, they wouldn't be required to be licensed. If you buy this system and don't want it monitored at all, are they required to be licensed?
No. In my opinion, no.
Okay, now, if you buy this system, but it's set up so that it would only be monitored by rapid response due to pre-programming, which is the way that I'm assuming they would do it. Now, they could do it other ways. You could call in.
Good remote access.
Yeah, yeah.
Remote access.
But assuming it's pre-programmed to rapid response in some fashion, are they required to be licensed?
I think so.
First would be that it would not be required to be monitored by rapid response.
I
Now I'm
kind
saying,
of had a different opinion on that. I mean, I've whether it's required to be with Rapid or not doesn't affect my opinion on it. I feel like even if they could use other people, but who they're suggesting, there has to be some joint venture in my mind between the two for them to be offering it. Even if they could use somebody else, which I doubt they could, that wouldn't really change my mind. I would still feel that they should be licensed if they're involved in the monitoring aspect.
They're in essence selling monitoring with their box. Right.
Right.
but you don't have to buy the monitoring.
No, but you're putting your shingle out to sell it. You're hanging, you're putting their paperwork in the box,
And
which
most
is
likely,
sales.
there's something on the outside of the box that says it too. I mean, there may not
Sure.
be, but
You can have this monitored if you like. It's not an alarm, but you can have it monitored.
But then I would go back to, why would you even want to buy it?
Doesn't say that on the box, you wouldn't.
I know.
So it has to.
Why would you?
Well, this, according to this email, they're out of California. If I have to, I can ask them to come in.
Well, all right, let me pose this question. Now, Radio Shacks don't exist anymore, as I recall, but you could go to Radio Shack and buy an alarm system and could have it monitored somewhere. What's the difference between that and SwitchMate here?
Radio Shack was not promoting monitoring through one of their preferred vendors or them or anyone.
If it has on the box, system has capability of monitoring, and you've got options of who you want to solicit your monitoring from, that's one thing. But if your system is only going to work with one monitoring company, then it's, what's the use in having the system if you can't pick your monitoring? And why would you want a system if you don't want it monitored?
Well, I agree with you in part that, why would you want a system if it wasn't monitored? That would make a lot of sense to me. But,
But if I want to sell a system out of the box that's got monitoring capabilities, it shouldn't be locked into one particular monitoring provider.
but our statute doesn't say that.
Okay, I have a question. Does our statute say that if it dials off premises, you must be licensed? If you've just got something on a wall wailing, then that's okay. But when it starts dialing off premises, you must be licensed.
No, if you installed a system, even a local alarm that didn't dial off premise,
But-
if you were selling and installing, but they're not installing.
But when it starts dialing to rapid response, whoever sold that system seems to me like they should be licensed if it dials off premises.
But you don't think an alarm installer that installed a local alarm had to be licensed?
Sure, if they did it, but the homeowner's doing it. So now we're back to the product maker that is manufacturing a product that is enabled to dial off premises.
Statute really doesn't address dialing off premises except in the exception, which was, in my opinion, a mistake from the outset, but necessary at the time. there was an exception put into the statute that allowed systems that did not require any wiring or off-site response. I don't remember the exact wording of it, but those systems, the intent there, those systems were going to be sold door to door. And so even though it was a simple installation, you basically set it on a shelf, and but those were door-to-door sales, and that was an exemption for that particular product, which probably doesn't exist at this point, so that they could go and sell that product, and there were some limitations put for that. The off-site monitoring doesn't really affect us anywhere else in the statute that I recall.
I don't know, ESA in connection with TCAP, in connection with most of your local municipality police departments, are all having seminars right now about false alarm laws and who they're going to fine and why, because they're dialing off premises and causing excessive runs. If they didn't dial off premises, there wouldn't be any excessive runs or no fines or no whatever. And I just attended one yesterday. Got a motion, go ahead.
I make a motion based on the information that they've presented in this email that they would not require to be licensed by the state of Tennessee.
Okay, we have a motion by Mr. Roberts that based on information presented, this switchback company would not have to be licensed in Tennessee. Do we have a second? Motion dies for lack of second. Do we have another motion to be presented?
Make a motion if they would like to sell this product, they need to come in so we can question them. Because there's a lot of things in this email that's very vague. And we've all discussed about what if. Could this happen? Could this happen? Could this happen?
Okay, we have a motion by Ms. Jones to ask the company to come into the April meeting. Do we have a second?
Second.
And we have a second by Mr. Cockcroft. All in favor, voice by saying aye.
Aye.
All opposed?
No.
3-1.
Okay. So what I'm
Not denying it, we're just asking them to come in so they
okay,
can
so it
further
is
clarify.
what I'm doing is sending back the email telling them we would like for their appearance at the April meeting. There was for
Yes, that we have
discussion.
some questions. Okay.
And can they do that by teleconference or something? Would they have to be in person? Or?
No, they would not have to be in person. We can probably do that by telephone.
I would be agreeable to that.
You probably not. Perhaps they need to send us pictures of the box or what it costs them. If they're going to do it.
I'd like
By
to see the
telephone.
papers,
Or
that
something.
come in the box about, would you like to have rapid response do this?
Any more information they could provide would be helpful.
Perhaps they could send everything except the actual components.
Could send us a box, couldn't they?
That's what I said. Send the box with all the paperwork.
With all the paperwork,
without
and we
the
can look at it.
components. Okay.
Hold on. I'm making my notes here. Well, thank you. the actual review, the 5-minute break, or continue on, whatever, however.
Yeah, sounds good.
I probably could have taken care of.
Okay, we're going to call back to order this meeting of the Tennessee Alarm Systems Contractors Board. Ms. Vest, I believe our criminal history review is next.
Yes, I would like to start with Exhibit A, please. I'm going to give you a few minutes to look this over. There are several pages, but basically what it is possession of marijuana, where he got probation for 2 years in 2014. He got 5 days confinement for having a switchblade and knuckles. The 4th, 2014. This is a registered employee application.
Didn't hear about I see he possession of marijuana. Where's the,
Is that possession of a legend? Marcus?
Mm-hmm.
Okay.
I've not found that yet.
Okay, I think there's an error here. We got this information from the company that sent in his application, and I believe they're talking about the wrong individual.
I have a man named Marcus Stallworth. Okay.
Yeah.
Yes. But the register of actions is for a different individual.
Yeah, because it was a DUI thing there, and it's got a different name.
Over a few more pages to the register of actions. And driving while intoxicated, and it is for a different individual.
That is correct.
No, it's not correct. That's the problem.
No, that's what. They've sent her the information, and I said, that is correct. They've sent her the information.
Yeah.
So we
Because
don't
this
have
is a,
Marcus Stallworth.
Stephen Fredericks.
Stephen, yeah.
Stephen Fredericks.
We don't have Mr. Stallworth's information.
Okay, we have some other, apparently they went to Denego, and it was, this sheet has the right name. The second sheet would actually did the registration has a different name. I think I need to go back to the company. This is an alarm employee, and we need to straighten this out.
That's good. So we'll table him.
Yes. So let's just move on to, I'm going to scratch through him and go to Exhibit B.
Our iPads have something different.
Oh, here's B, way down here.
We don't need to be reading those out because that has nothing to do with the individual we're speaking of, so don't.
I was just
mention the
trying to find
names.
the exhibit.
Okay.
It might be number 16.
I found
Okay, well, now we're going to Exhibit B.
Eric Seedorf.
Yes, sir. Let's try this. I know it's kind of old. It's 10/15 of 1992. He's found guilty of burglary and vehicle theft. He does have a written explanation, and it was 25 years ago. Also a registered employee.
Right, that this person's been in the registered position since 2013?
Is he in a monitoring station and they're monitoring in Tennessee now, or is it something different?
This is an Indianapolis company, but not mean that he was a certified technician in the state of Tennessee. He's from probably when they hired him. That's a mistake they usually make. We need to make a note of this.
We don't have the arrest record or anything
No,
like
sir,
that.
you,
All
you
we
don't. You don't have that. I have that. It is a 10/15 of 1992 burglary vehicle theft. The court disposition is guilty.
Is this in Tennessee?
No, ma'am, is Indiana.
Well, he says he's been arrested in Tennessee or any other state, so I guess that covers everything.
Was a long time ago, but it troubles me that part of the response is saying it wasn't auto theft, it was a scooter that makes it auto theft, but it was a break-in, and we put in burglar alarms, that's what we're regulating. But it was a long time ago. This person wasn't requested to come in. This wasn't.
Oh no, this
isn't.
is just your review of
Okay.
his record. He, like I say, he has the explanation in the back, like you said. Where he got a moped, and since it has a motor, it's considered auto theft.
Whether it's auto theft or not, my concern is the breaking and entering.
He was 20 years old when that happened. .45 now.
That's a long time ago, especially for someone at that age.
No other offenses other than this, just
That's
this
all.
one?
That's
The
all
whole thing
we had
showed
on
up?
the record.
Madam Chairman, I make a motion we grant this application as registered employee for Mr. Eric Seedorf.
We have a motion by Mr. Roberts to approve this employee registration application. Do we have a second?
have a response from the, well, that's his one response.
We're waiting for
I
a
answered my own
second.
question. I was going to ask, was
We have a
there,
motion to approve, but we don't have a second. And I think Scott was looking at something, so I was giving him a second. The motion dies for lack of a second.
I just have a hard time approving someone that did break in somewhere without any more of an explanation. And most likely, if the person were to come in and talk to us, we would approve them. That may not be fair, but I just don't feel comfortable.
Are you telling me we need that as an Indiana, ask the individual to appear?
Yes, ma'am, that's what for me to move forward on it, I would have to have more information from them, whether they wanted to writing or or appearance.
What, are they gonna be an installer or in a monitoring center? With it being Indiana, it sounds more like a
Technician.
Just give a minute, I'll have to look the company up.
Position was certified technician, I believe.
Classification they have is fire.
licensed in Tennessee?
Yes, they have a license.
Todd, I agree with you. I am very loath to ever grant a application as a registered employee to somebody who's been involved in burglary or break-ins or stuff like that. I really am. And that happens to be a particular hot button for me. However, looking at the facts here, the guy that did this was 20 years old when he did it. He was a kid. And it was 25 years ago, which would put him middle-age 45 at this point. He hasn't had any other offenses since that point. And so that was the reason I would be willing to, again, with the qualifications that I look very harshly upon anybody that's been involved in a break-in. But looking at those circumstances, the age of the individual at the time he broke in and the amount of time that's elapsed since then, that was the reason I felt like it would be worthwhile to that particular individual would be a minimal risk in terms of being a registered employee.
We don't have a lot to look at, and I mean the one thing I'm going back to is I agree with you on all what you said. I'd feel better about it if his explanation had been a little more glowing or forthcoming. But the explanation is, oh, I didn't really steal an auto. I broke in somewhere. It's not saying I'm sorry. I never did it again. I realize how wrong it was. It's just, oh, I didn't really steal a car. I broke in a building. And that concerns me. Maybe if we had something from him saying something different, recommendation letters from his employer or friends, family, but to look at his explanation, and it may not be fair to him, but that's all I got. I have the fact that he broke in somewhere, and his excuse is, well, it says it was a theft of an auto, but his excuse is, oh, I didn't really steal an auto. I broke in somewhere. So
Did the QA send anything in?
that's my only concern. I agree with you. I guess if there was more there explanation, but it just doesn't give me a whole lot to.
Maybe some recommendations from a QA or others might have some bearing on that.
Right.
That makes sense.
I mean, we've approved someone that had. They were an accomplice to a bank robbery, but he came in and talked to us, and it was a long time ago. And he, I felt much better about that, and I might this person may be even more upstanding than that person. I don't know, but what I have to look at doesn't make me feel good about it.
And what we need to do is go back and say we in order to approve this application, or not necessarily, let's don't say it that way. Say it that in order to further consider this application, we would wish for some additional information, possible references from people that know this individual, letter from a QA. We just need some more information. Maybe that'd be the best way to say it.
And then just pass it till April.
Right now, I'm just assuming that this guy's a middle-aged fire alarm technician that stole a moped when he was a kid.
Okay. So you just want the documentation, you don't need the
Let's get
individual
some.
to come in?
Tell him we want some more information.
Okay, I got
I
it.
think it'd be the best way to see it.
Unless he, by some chance, is working in Nashville in April and can drop by, I think written documentation to further his case would be sufficient.
All right, I can do that.
Okay, Exhibit C.
This is kind of old too, this. 2009 shoplifting where they got 1129 and driving on suspended license. Also a registered employee. You have an explanation in there, and you have a qualifying agent as well.
Here our situation is we've got a monitoring center employee that 10 years ago at age 20 shoplifted some cosmetics. Basically. Other is a motor operator offense, which is really not something that we would consider. She was age 20. That was 10 years ago. She shoplifted some cosmetics. Got caught. Works as a monitoring center employee. Madam Chairman, I'd make a motion that we grant this registration.
Second.
Okay, we have a motion by Mr. Roberts, a second by Mr. Cockcroft to grant this employee registration. Exhibit C. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
All right, I believe that it will end that section, and we can go right on to the education, if you please. Start this off. We sent these courses out to Ken. Honeywell Homes Security Solutions has 1, 2, 3. Logic had 2. And then, Ken, I believe you had ViconNet as well.
Was I the only one that got to review these courses?
Scott has some.
I was going to say, I just didn't realize my good fortune. All right, let's take them one at a time then. The course, Selling Smart Home Solution, a must for growing your RMR, was requested for 1 hour of continuing education and initial application. I don't believe that would qualify for initial application, but 1 hour of continuing education would seem perfectly appropriate. The course, the Security and the Internet of Things, was requested 2 hours of continuing education. That's from Interlogics, and I would think that appropriate. Security Solutions had submitted a course, Vanco HDMI focusing on 4K for 1 hour of continuing education. I felt that was appropriate. Security Solutions also submitted a course called TrendNet, Indoor and Outdoor Wireless Solutions Made Easy, for 1 hour of continuing education, which I felt appropriate. Security Solutions also submitted a course called Commercial AV, Providing a Solutions, and the grammar there is not perfectly correct, but probably the course was okay, for 1 hour of continuing education, which I felt like was appropriate. Now, Vicon Industries submitted an unnamed course for 4 hours, where they indicated they wanted it for all of the above, and I had some difficulty with that. After going through the course carefully, it appears that the course is named Valerius and Vax Access Control. That wasn't listed on the form, which was one of the. It's supposed to list the title of the course, but they didn't see fit to put that on the application here.
This has got common code laws and common sense of fire-rated openings.
Nope, I didn't have that one.
That's what's lit. See here? It's 4 hours, too, of continuing ed.
I didn't have that course. I had one. Was that by Vicon?
Yeah, ViconNet.
The Vicon
Did
course.
you have a ViconNet?
No, I didn't have anything from Vicon.
Okay, the second page here says,
That's what he said.
yeah. ALERUS and VAX training course objective.
Yeah. Valerius and Vax Access Control
Yeah.
was the course that I had, and I
It's
would.
listed on the education report. It's not what was sent out. I think is where the confusion is.
and they requested 4 hours. I would approve that for 4 hours of employee training and 4 hours of continuing education, not for initial application.
They've
So,
only requested continuing ed on so this is something totally.
I didn't print out all 112 pages that was sent to me. My office manager accuses me of killing trees when I print all this stuff out. But it saves the money here, so I guess it's a good thing.
So you want me to put this down? They did say 4 hours of continuing education, which you're saying. is
4
okay.
hours of continuing education. The block that was checked on the application form was for all of the above. It would be suitable for continuing education and for employee training, 4 hours. Yes. So I have read those. I assume they're into the record now. I would make a motion that we approve those courses that I just read into the record for the times indicated.
Okay, we have a motion by Mr. Roberts to approve the courses as read into the record. Do we have a second?
Second.
A second by Ms. Jones. All in favor, voice by saying aye.
Aye.
All opposed. Jenny, do you need these for reference? Or you'll get them? Okay.
All right, so we got Ken, so now we're going to move over to Scott's, the ones that we sent out to him.
Okay, I had Mongotel, does it have the title in here? Voice over IP networking. It was for an hour of continuing education, and it's fine. It looks, and it has a layout of the course along with times, and it definitely looks fine. Is there, am I missing a page on Slayton Solutions possibly? The Slayton Solutions. Put on here for 2 hours of continuing education, but his scope of the class only shows 40 minutes. I think he usually does a very good class, but this doesn't show anywhere near 2 hours worth going by his times.
Okay, you should have the first page that starts with 2018 Slayton Expo outline,
Right.
110 of 18.
Are they in here? Are they in the?
Second page starts with number 3, types of.
I don't think I got that in the PDF. As long as there's more outline that completes the 2 hours, his is fine for 2 hours.
Yes, sir, there's a whole page there, another page.
In the Southeast Security Products, there's megapixel crash course, door openings and access control hardware class, IP video management essentials, ELK M1 essentials, and networking essentials. All of these are fine for the 2 hours they requested, but they also have initial application, which it wouldn't be applicable for that. It'd just be for continuing education, which is what it lists in the iPad. I believe it's just continuing education. I recommend all of those with the exception of the initial application on the Southeast Security.
Okay. You can put it in the form of a motion.
Okay, so I would make a motion to accept for continuing education at all of the hours requested for the courses that I had reviewed that I just read in.
I think she can get them from the staff on putting them into the minutes, but you read them out as you went through them on the list. We have a motion by Mr. Cockcroft. Do we have a second?
Second.
And a second by Mr. Roberts to accept the courses for continuing education as read into the record by Mr. Cockcroft. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. Now, did we cover all of these?
No. Let's go back to Ken's for just a moment. He did logic, but he only did the first one, security and the Internet of Things. I didn't make a notation for commercial integration.
No, we don't have. I don't.
I only saw the one Interlogics course, which was Security and the Internet of Things for 2 hours of continuing education. Now, there was a Honeywell Homes course, selling smart home solutions, a must for growing your RMR.
I thought there was. Did you have the security solutions on Vanco HDMI focusing on 4K?
We had it all attached. It didn't come through to you, Mr. Roberts, that way.
in one PDF.
I may not have seen it. I got 4 or 5 PDFs.
Okay, did we vote on the one, the HDMI on 4K? I don't remember it.
Yes.
We did?
Yes, that was one that I had. Vanco. 1 hour of continuing education. I may have just overlooked the other courses.
Yeah, so they're asking for 2 hours of continuing education. Oh. And they are going to have a course. Can I hand?
Sure.
It's on. I'm looking at it on the iPad. You're talking about security and the Internet of Things? Or that's the second
had
one.
that
It's
one.
already been approved. He wants this one here, commercial integration.
What page are you on, Scott?
Page 5.
I don't know. I'm just scrolling like crazy.
And go to like page 1.
Well, I was on somewhere like page 45 or something. So.
Page 5 is Honeywell.
Okay, it's different on your.
We're looking for Honeywell.
No, it's
Interlogics.
they're all in one big.
It's on page 62 on mine.
That was the one she just gave me, commercial integration.
Starts on 59, I believe.
Here you can have mine.
I'm looking at you right
Oh, okay.
I think I finally found it.
All right, I would, let's read into the record. This is the Interlogics course. Title of it is Commercial Integration. It is for 2 hours of continuing education. Looking through the information presented here, I would feel like that would be appropriate. So I'll make a motion that we approve that course for 2 hours of continuing education. It does have an ESA event ID of 16-4751.
Okay, we have a motion by Mr. Roberts, a second by Mr. Cockcroft to approve the Interlogics Commercial Integration course for 2 hours of CEU. All in favor, voice by saying aye. Aye. All opposed? The motion carries.
All right, Madam Chair, that's all I had to present.
So I guess none of our appearances are.
No, ma'am, the appearances didn't
They're
show
all
up.
disappearances.
Their applications, we've already reviewed them for the criminal records. Didn't appear, they'll be closed. The application will be closed.
Do we have any unfinished business that we need to address today?
Cody, there was a form here at my desk, Board of Commission conflict of interest statement. This is something we need to fill out and get back to you.
We've been
Okay.
doing it online, but this time we've done it hard copy because we've been doing it each year. And then signing and scanning it and send it back to Shauna or Beth in the past, but this year we're signing it here, which is a lot easier.
I got to fill
All
out
of you
all
have
this,
one,
so.
don't you?
No, you don't.
We
You just
already
have to
turned
sign
those
it.
in, I think.
Okay, all
Unless
right,
you-
yes, please, if you
Exceptions in here
would.
that I'll need to fill
Oh, I
out.
Sign
don't have
those,
any.
and let's get them, you're the only one who hadn't turned it in yet, sir?
He's
Okay.
got some
Oh, I have not.
exceptions he's got to fill out.
I will do
Oh,
that.
oh, he's got, okay,
The rest of us fly off the radar.
okay.
Okay.
Well, for instance, it says disclose the names of all current and former employers for the past 10 years regulated by the Board of Commission. That in. Y'all didn't
That
do
would
that?
just be you, wouldn't it, for the last 10
Did it
years?
say employers or employees?
All current and former employers
Oh, well, it's just,
for the last 10 years.
So you've had your
Right.
business, okay, we're okay. I think that's you. Unless you got a secret life here that we're not
Well,
aware of.
employees name of all jobs currently held by immediate family members. See, I've got to fill that in.
Start to work.
And I've got to list all the de minimis phone numbers and personals and identities and of your immediate family ownership or in interest or indebtedness. Does that include the banks? No, I don't guess. I'll get the information to you.
Thank you very much, I appreciate that.
Do we
Thank
have
you.
any new business to discuss?
I don't have any new business.
This meeting's adjourned.
Thank you.
I
I
take
just
down
always-
business.
Your last no after she was